and it was a series of questions, really, asking what is going to happen, because we had very little idea. But now we certainly have some certainty, and we're making our way through this brave new world. And the way that I was going to structure my short talk to you this evening is just to look at the way that we dealt with international cases in this jurisdiction before Brexit, where we are now, and also just to look very briefly with you at the recognition and enforcement provisions under the 96 Hague Convention, because I imagine that's going to be an area that will interest many of you, particularly those of you practicing in France, obtaining orders relating to children and wanting to know how best to enforce those orders over in this jurisdiction. So first of all, just looking at what the legal position was prior to the 31st of December 2020, we were operating, of course, with the Brussels II revised regulation, which was a very comprehensive code in respect of cases returning concerning children. It was really the cornerstone for jurisdiction in children cases in this country, not only intra-European cases. It's a regulation which buttresses and reinforces many of the provisions of the 1980 Hague Convention. It contains provision about transfer of proceedings, deals with a request for information and cooperation between authorities, and also has a code which sets out how orders are to be enforced and recognised across jurisdictions. And of course, one of the enormous benefits of the regulation is that it was governed and presided over by the CJEU, so there was harmonious interpretation of the regulation and a forum where member states could seek to adjudicate and seek clarification in relation to how the regulation was to be interpreted, and that is something that was implemented and enforced across the EU. That's obviously gone now. We no longer have the benefit of the CJEU, and very sadly, we won't have the benefit of what many of you who are joining us from France will benefit from, and that is the Brussels II recast regulation, which I understand is going to be coming into force next year, so 2022, and has some really interesting, innovative provisions which really interest me as an international children lawyer. Some of the provisions about the obligation on how to hear the voice of the child, the clearer deadlines on how to deal with abduction cases, the clearer rules on how to place children abroad, the harmonisation of the rules on enforcement, and all provisions that, you know, I personally would love to have seen implemented here. And regrettably and very sadly, as a result of our exit from the EU, we no longer have the Brussels II regulation, the benefit of that regulation, and no longer do we have any prospect of the recast regulation being implemented, well, anytime soon. That is until and if one day we change our mind and seek permission to rejoin the club, if you'll have us. So that, in very summary form, is what was going on before the 31st of December, the regulation that we looked at to govern many international cases and many cases which operated in an English-French context and within a European context. So what have we been up to? What have we been doing since January and since we've lost the benefit of this regulation, which we were all very familiar with and used to dealing with? Well, there are obviously some cases which are in the transitional period, so cases which were commenced before the 31st of December will still have the Brussels II revised regulation applied to them in certain respects. So if you've got a case which falls into this category, what you need to do is you need to look at the EU withdrawal agreement, in particular Article 67, and Article 67 sets out which provisions of the Brussels II revised regulation would continue to apply to proceedings commenced before the 31st of December. So those provisions deal with jurisdiction, those would continue, the recognition and enforcement provisions would continue, and also the cooperation provisions of the Brussels II regulation would continue to apply to any of those transitional cases commenced prior to the 31st of December. because the legal landscape now is completely different. The legal framework is now completely different for cases commenced after that time. So the answer is very simple. The Brussels II revised regulation just simply does not apply, but we do have an instrument which is in fact very similar to the Brussels II revised regulation. That, of course, is the 1996 Hague Convention, which, of course, as many of you will know, was actually the predecessor to the Brussels II revised regulation, and is the convention that the Brussels II revised regulation was in fact modelled on. So what has happened in terms of our domestic approach and legislation is that we have implemented the 1996 Hague Convention as a matter of UK law. That's by virtue of a regulation which entered into force in December. And that is now the convention which will govern a lot of similar issues that were governed previously by the Brussels II revised regulation. Now, I'd be interested to hear from Veronique whether the 96 Hague Convention is an instrument that you're used to dealing with in France. Certainly from an English lawyer's perspective, the convention isn't something that we have dealt with on a day in, day out basis. It's been described by a leading academic in this jurisdiction as a sleeping giant. And that is because even though it was implemented as far back as 2012 through an EU law mechanism, the primary basis of looking at jurisdiction, cooperation, enforcement recognition provisions was the Brussels II revised regulation. So actually the 96 Hague Convention hasn't been a focus for international family lawyers and international children lawyers in this jurisdiction. So that sleeping giant has awakened, and Florian and I know this. We've had first-hand experience of dealing with an extremely complicated case under the 1996 Hague Convention, which was really looking at uncharted territory in terms of how certain provisions of that convention were to be implemented, how they were to be interpreted and enforced by the judge in question. So it's leading to some interesting case law, and there certainly have been an increase in cases which look at the 96 Hague Convention. But that is now going to be a convention which has increasing importance in this jurisdiction. And just looking very briefly at the sorts of topics that the 96 Hague Convention deals with, many are similar to the Brussels II revised regulation. So, for example, you've got a chapter on jurisdiction, you've got a chapter on applicable law, which is absolutely fascinating and not something that has existed in the Brussels II regulation previously. And that is a totally new area for us as children lawyers, and very interesting indeed. The convention also deals with recognition, registration and enforcement, and it also has provision about cooperation and collaboration when it comes to information sharing. The convention has some key differences to the Brussels II revised regulation. So I would say that it does some of the work of the Brussels II revised regulation, but not all of it. So, for example, there are some key differences. One of those is that it is possible for a child's habitual residence to change during proceedings. That's not a concept which we're used to applying or implementing in this jurisdiction. That's quite new to us. There's no automatic recognition of access orders. There is a different approach when it comes to abduction and how child abduction is dealt with. There isn't the same streamlining process that the Brussels II revised regulation provided us with. There's no presumption that there will be adequate measures in the country where the child is being returned to. There isn't the same emphasis on the home country from where the child has been abducted from to make decisions about the child's welfare. So there are some very interesting differences. There are differences in nuance, in language, and also in scope. So as an English lawyer, it's certainly an interesting time. There's going to be, I think, many more cases which look at various provisions of the 96 Hague Convention and how it's to be interpreted and enforced in this jurisdiction. Of course, one of the things which is regrettable is that we don't have an equivalent of the CJEU when it comes to looking at those sorts of issues. So it may be possible for different member states to the 96 Hague Convention to interpret the convention differently and to implement the convention differently. So it's going to be very interesting to see what differences emerge in due course. I'm just going to turn now finally to look at some of the recognition and enforcement provisions of the 96 Hague Convention. And it's really important to bear in mind that the Hague Convention's aims in terms of recognition and enforcement of orders concerning children are very similar to the Brussels II revised regulation. It is about collaboration, it is about comity, and it is about respecting other courts' decisions whenever that is appropriate. So in order for an order to be recognised automatically in England and Wales without any steps having to be taken by any party, that is something that is done automatically. However, recognition, whilst being automatic, is something that can be challenged under the grounds that you are used to seeing in the Brussels II context. For example, a party not being served, the voice of the child not being heard, if recognition might be contrary to principles of public policy. But what does need to happen prior to a decision being enforced is that there does need to be a procedure undertaken in order to ensure enforcement. That is set out in Article 26 of the 96 Hague Convention, which says that the enforcement provisions need to be swift and rapid. That is the wording of the convention. Now, if you have an order in France that you're seeking to have enforced and recognised in this jurisdiction, your first port of call will probably be to pick up the phone, speak to an international children's specialist in this jurisdiction, because the applications that need to be made and the approach that needs to be taken are governed entirely by domestic law. The procedure is governed by the Family Procedure Rules 2010, Part 31 and Part 31A. The application needs to be made to the principal registry on a C69, and unlike the Brussels II revised provisions, there is no need for a certificate or an annex in support of your application for enforcement. But what is quite onerous, and attention has been drawn to this, is that the rules do set out quite a lengthy number of documents which need to be submitted in support of any application for enforcement. And it is a very, very lengthy list, and in fact the rules themselves have not gone without some criticism from the judiciary. There was a case called VP in 2014, where Mr. Justice Moylan, as he then was, he's now in fact Judge of the Court of Appeal, observed that the procedural requirements for seeking the enforcement of an order were actually very, very onerous, and they challenged the concept of simple. So perhaps in England and Wales we're not doing as good a job as we could be to implement Article 26 of the 96 Hague Convention, which provides that there must be a rapid and simple procedure when it comes to enforcement of foreign orders. But I would hope that as practitioners' experience of the convention grows, as the judiciary's experience of the convention grows, that there will be more streamlined processes put into place so that a more simple and rapid process can be implemented. So just to summarise in terms of where we are, we're at a very early stage. We're getting through it. There is life after Brexit. Things are certainly a lot more uncertain, but as from a lawyer's perspective, they're certainly also a lot more interesting. And the 96 Hague Convention does appear to be the solution to many of the problems which leaving the EU has presented for those of us who practice in the field of international children law, and of course the families that we serve to assist.
Thank you very much, Mevesh. That's very interesting. I can see there's already a few comments in the chat box. I don't know if these are questions. Yes, so we can look at them after then. Our second speaker tonight is Véronique Chauveau. Véronique is a French advocate specialized in family law. She mainly works on international matters. She won international competitions for barrister. She's a member of Lawyers Without Borders. She has over 25 years of experience, in particular in representing parents whose children have been the victim of cross-border parental abduction. She has worked as an expert for the court in New York, Dublin, London and Istanbul. She's also worked as an expert for the European Union on a mission to Moscow, lending assistance on implementing the 1980 and 1996 Hague Convention. So very warm welcome to you, Veronique, and up to you now.
Thank you. I just want to say that whereas Melwish seems very enthusiastic about the 1996 convention, I see that there are real holes in it that will not be fulfilled by this convention. Adoption is not a problem because we still have the Hague Convention on abduction, but alimony is not covered by the convention. Inheritance and asylum is not covered, save for the emergency measures to be taken for migrant children who ask for asylum in one of a member country. I would like you to refer to the marvelous work done by Professor Lagarde in his introductory report. Regarding the alimony issue, I would like to inform you, if you don't know it, that there's a very old Anglo-French convention dated 1934 for recognition of foreign orders between France and England. Maybe we need to do a little bit of archaeology, judicial archaeology, to find out these tools. The problem with the Hague Convention, which is in a way very close to the Brussels II bis regulation, is that, as Melwish said, the proceeding for recognition should be simple and quick. And Professor Lagarde says it's lex imperfecta because it doesn't say how it should be. So it leaves a large interpretation to member states to decide how it should be done. On the condition of refusal of recognition, there is one important point. In case of kafala, or which, as you may know, is the Muslim closest way to adoption, which is not adoption, but closest way to adoption, or putting a child in foster care, the order will not be recognized if previously to the order made, the state where the child is going to be in kafala or where the child is going to be put in a foster home has not been consulted first. So that's very important if you do protection of children, to know that the central authority of the other country has to be consulted. There's one point is important, is the transfer of jurisdiction. It's more or less far more convenience. And I don't know if it's going to work, because if we see how Article 11 works in Europe on Brussels II revised, it's not working properly. So I don't know if it's going to work. But anyway, this is possible. It's also possible there's a mechanism close to Article 20 of the Brussels II revised regulation, by which the court, where a child is, even if he's not a resident, but the child has connection, can take emergency steps. The problem being that it will stay in force until the country of habitual residence has taken another order. Problem is, explain to me how it's going to be recognized and enforced if the other country is not in agreement for that. Well, anyway, I don't see the 1996 Hague Convention as a proper tool for protection of children, but it's better than nothing. So we'll see. Being said that in France, even if we have a child in a non-member state of Europe, Article 8 of the European regulation of Brussels II revised applies. Like I can ask a judge in France when a child lives in Bahrain or in United States, who is not a member state, that because the child lives out of France, Article 8 should apply. Hence, the French court has no jurisdiction. Because in the 1996 convention, there is also, like in Brussels II revised, a possibility for the judge ordering divorce to take on jurisdiction if both parents agree and if there's criteria of connexity with the state where the divorce is going to be made. I don't know, in fact, because I never had a case like that, I don't know, in fact, how the judges are going to analyze this in England, Wales, Scotland, and France. I don't know. We'll see how it is. So basically, I do hope that France, Germany, and Spain, who actually are fighting against accepting Great Britain in the Lugano Convention, will soften their positions, because they should not think about their pride as states, but of the children and the parents concerned, because we are not working for states, we're working for parents and for children. And whereas the Brexit has occurred, parents will always cross the channel and go to work in England or go to work in France or come to retire in France or whatever. So the children will go back and forth, and we need more protection about that. That's all. Okay.
Thank you. Oh, can you hear me? Yes. Thank you very much, Veronique. That was very, very interesting too, and a bit scary for us. With regards to the second part of this evening, we're now going to deal with finances, family finances, and our third and fourth speakers tonight are Alexandre Boichet and Lisette Dupré. Alexandre is a French avocat specialized in family law. He is a renowned specialist in international family litigation. He is dealing in particular with complex of jurisdiction or laws and recognition of foreign judgments. From 1998 to 2002, he was the Chief Legal Officer in the Office of International Legal Information at the National Information Center on the Rights of Women and Families in Paris. He specializes in drafting international prenuptial agreements, divorce settlements, and parental authority agreements. And Lisette is an English solicitor specialized in family law. She also has a wide international practice. She has a specialist expertise in complex jurisdictional issues, including securing financial remedies following foreign divorce and maintenance for abandoned spouses. She was ranked as the next generation partner by the Legal 500 in the 2020 and 2021. She's the founder and chair of the EU Maintenance Regulation Working Group, comprising senior lawyers and judges. And well, very welcome to you both, and over to you.
Thank you very much, Floriane. Alex, shall I put my table up, and do you want to start?
As you want.
As you want. Okay, let's start with that.
Tiens, donc le premier ABC de l'anglais. No, in fact, the question was to explain what has changed in France since Brexit regarding the situation, but regarding international family case, and especially case regarding finance. But in fact, for us, in practice, nothing changed right now. We still apply the same European regulation for the divorce, the Brussels II revised regulation, and we still apply the maintenance regulation to establish jurisdiction. So the things are the same for us. The only thing is that on the Brussels II revised regulation, there is a possibility to apply internal law if no jurisdiction of a member state has jurisdiction for the case, And that could occur with a case with British citizen when it was not possible before that, because there is the protection of the Article 6 and 7 of the Brussels II revised regulation. This is not the case anymore, but the issue with that would be that a French court that may have jurisdiction based on French internal rules may not have jurisdiction to deal with the maintenance obligation, because for the maintenance obligation, the maintenance regulation establishes rules of jurisdiction that the French court has to apply, even if the defendant is not habitually resident in a member state, but these rules are applicable in any case. So there is this issue. We have also the matrimonial property regulation that came into force in 2019. But that, in any case, it doesn't change anything for you, because United Kingdom did not opt in this regulation. To you, Lisette.
To me. So thank you for that introduction, Alexander. What we're going to try and do is just gallop through some of the changes or the focus that will be for family French and English lawyers now, if you're dealing with a case as between France and England. So we've talked a lot about Brussels II regulation, and this table just demonstrates that the Brussels II regulation as between England and France no longer applies in terms of new cases. But as Alex has said, of course, it applies to France for reasons of jurisdiction and so forth, but not to England. So there is a gap there. Same with the maintenance regulation. We've got the Hague 2007, which we've always had, but that wasn't really a focus for France and England before Brexit, and now it's going to be in the in our four. It's effectively replacing the maintenance regulation. And we've got Hague 1970, which is on this table just to demonstrate that actually France didn't sign up to that, so we can't use that to replace recognition of divorce, which used to be dealt with by Brussels II revised. And Hague 1973, again, technically we've both signed up to it, but it's been replaced by Hague 2007. And then the last issue is the Lugano Convention, which, as we've discussed, was applicable as between France and the UK before we left the EU, but now we're not able to re-sign the Lugano Convention, so at the moment it's not going to apply. But in any event, it was not used because it was trumped by Hague by the maintenance regulation. That's just a gallop through distinctions, I suppose, now and then between before the end of the implementation period and where we are now. I was just going to spend a few minutes discussing the maintenance regulation and the Hague Convention, just so that you're clear on what those two are. The maintenance regulation deals with just maintenance, and of course it was directly applicable to the EU 27 and still is, but just not to the UK. The Hague Convention is actually very different because it isn't a regulation, so any country in the world can sign up to it, and there are 42 signatories currently. But it operates very different to the maintenance regulation, even though it does do a lot of what we're going to need it to do in terms of recognition or enforcement and and recognition of maintenance orders. But you've got to remember the maintenance regulation had direct rules on jurisdiction, which we will no longer have as between France and the UK. And the Hague Convention, it does apply differently between member states or between signatories. So you need to read what the UK have said in their reservations and declarations and what France have said to understand, or the EU have said to understand how it's going to operate as between the UK and or England, Wales and France. So maintenance regulation obviously dealt with jurisdiction, applicable law, recognition and enforcement. It was a 2011 regulation, and it dealt with maintenance obligations only. The regulation still applies, as Mevish has mentioned about Brussels II, to cases that predate the 31st of December 2020. So it's still, and it could in fact apply to cases for years into the future, because you could be enforcing a maintenance order that originates from a divorce in 2020, maybe in 2030. So the maintenance regulation hasn't disappeared. It could still be used, but only for cases that were instituted before the end of the implementation period on the 31st of December. The Hague Convention, as we've discussed, deals again with just maintenance. It's establishment of a decision, recognition, enforcement, and there are indirect rules of jurisdiction to factor in, and the scope is child and spousal maintenance and some forms of other family maintenance. We talk about maintenance. What do we mean by maintenance? Well, it's not defined in either regulation or the convention, but we know that the idea of the convention was to deal with child support and other forms of family maintenance. And so you just need to look at declarations to see what that might mean in terms of whether it's child maintenance up to the age of 18 or 25 or whatever a country has specified. The maintenance regulation, again, there's no definition, so you have to look at case law, and Van Boegaard tells us what maintenance means as best as it can, and it does refer not only to spousal or regular payments, but possibly lump sums as well. So that's the scope. The last thing I just wanted to say before we look at a couple of cases to illustrate what has changed between a couple that have connections with France and the UK is how we recognise divorces. So before the end of the transitional period, we had Brussels II Revised that told us how we would recognise a French divorce or a Spanish divorce, and you would look at Article 21 and Article 22 of the Brussels regulation. That's gone now. So and we, as I say, we haven't got Hague 1970, or England has England Wales has Hague 1970 with about 12 EU countries, but France is not one of them. So if you're dealing with another jurisdiction, you could look at Hague, but we are looking at domestic law. And for domestic law, recognition of a divorce is actually it's quite liberal in the UK. So as long as it's a civil court that has granted the divorce, and that the service has taken place and there's been an opportunity to respond, then it's likely that a divorce is going to be recognised without a difficulty. Even religious divorces can be recognised as long as they're registered and they comply with our rules on that. So that was all I was going to say. Alex, did you want to cover anything before we looked at the cases?
Just before the cases, yes, I would like to say just about you say to complete that indeed today after Brexit the situation is more a situation about recognition, in fact. Okay, because about the applicable rules, of course, each country will apply its own rules, but the question is more about the question of recognition. And regarding what Lizette said about recognition, I think that even if we could have some fears, in a way, I think that we need to be reassuring, because regarding what Lizette said, it means that a decision that has been made in France in a divorce will mean that there is connection with France, will be probably recognized in England. And this is the same in France. We don't have the Hague 1970 Convention on recognition of divorce, but the French case law is very, very liberal to recognize a divorce made abroad. So on this point, it's okay. On maintenance obligation, indeed, we have the Hague 2007 Convention that is weaker than the maintenance regulation. It is clear. But this regulation provides some very strong rules in terms of enforcement. And I think that in terms of enforcement, this text is very, in fact, is very innovative and is very good. The only issue is that the British government should take the measure to ensure a quick proceeding to facilitate enforcement and not do like it has been in France, where we don't have quick proceeding when, and this is what Veronique was saying before, she said that in the 96 convention, Paul Lagarde explained that there is rules to recognize the foreign order, but these rules, they say that it should be quick, but the way it should be done, it is not explained. In the Hague 2007, it is explained. They have taken into account the miss of the 96 convention. But even if it is explained, the member states should apply it and adapt their internal law to do it. And in France, this is a nightmare, because I have read many articles to the French Ministry of Justice, and I said, you should change this article. And they said, no, we don't need. Yes, they need to do it. But, and I hope that in England, you will need to push on your government to adopt. And if you read really the articles from the Article 20 to the Article 30 of the Hague Convention, you will say that it is much more efficient. And for the recognition of divorce, you know that in France we have divorce without judge that we can do and register with notary. And always we have an issue regarding the enforcement of this divorce abroad, because and regarding the consequence of the divorce and financial consequence of the divorce, that this is a benefit of Brexit in a way, because this order with the financial consequence of the divorce, maintenance consequence of the divorce, were not recognized and were not enforceable with the maintenance regulation, when this agreement are enforceable with the Hague Convention, because you have the Article 30 of the Hague Convention that states that agreement made by the parties and enforceable in one country should be enforced in another country. So it means that this kind of French divorce will be enforceable in UK. Okay, sorry, I
No, that's fabulous, thank you. So just to illustrate the changes that couples are facing, we've just got a couple of examples that we'll work through. The first is taking an example of a husband and wife that are both French nationals, but they've resided in England for 20 years and their assets are in England. And we're just going to quickly look at what the couples could do before the 31st of December in terms of divorce and finances, and what's changed, if anything, afterwards. So dealing with England, where may a couple in that scenario divorce? Well, they're living in England, so you've got Brussels to revise Article 3 that tells us the jurisdictional rules, and there's lots of connection, habitual residence with the UK. The Liz Pendon's rule applies, so if there was any application in divorce in France, then you would have a very simple rule about first issue that would deal with that. And of course, applicable law in England and Wales is England and Wales, English law. Since the end of the transitional period, or the implementation period, in England, we don't have Brussels 2 anymore, but what we've replaced it with is Domicile and Matrimonial Proceedings Act, which basically mirrors the same jurisdictional grounds as Brussels 2 revised. Plus, we can also issue on sole domicile now. So it's opened up the possibility for divorces. It doesn't change this case because this couple are both habitually resident in England, so that's no different. There's no race to court, so if there is any competition, it's going to be dealt with by way of forum non-conveniens. There's lots of connections with England for this case, so again, this couple is likely to have a divorce and of finances dealt with in England if there's any kind of dispute there. But I'll leave Alex to deal with how the French court might look at that if, for example, the application for divorce comes second in time to a French petition, and any orders that might be made. Will the divorce be recognised in another country? So will a French divorce for this couple be recognised in England if it was a French divorce? And before the end of the transitional period, Brussels 2 said yes, look at Articles 21 and 22, and I've got no reason to assume that there would be a problem, other than Alex's comment today about how they divorce in France, but assuming it's a civil divorce, certainly no problem. Then if it was a French divorce, what about post the end of the transitional period? As we've said, our domestic law is very liberal, so as long as it's a civil divorce in France and there's no reason such as not, a couple not dealing with due process, and there's no existing decision in England that would be incompatible with recognising it, then that divorce would be recognised. What about the finances? So if you're divorcing in England, jurisdiction flowed from that under our domestic law, but you would have to meet the maintenance regulation jurisdiction to have a maintenance application in England. There's no problem with that. There's lots of connections with England with this couple, so you would have maintenance and sharing claims in England if divorce was issued before the end of the year. If it was issued after the end of the year, so 1st of January this year, then again, the divorce in England, the jurisdiction is domestic law, habitual residence, and we can have sharing and maintenance claims. So there's no change there. Same answer. Yes, divorce and finances in England. But what about recognising a French financial order for this couple? Well, the maintenance regulation, if it's issued before the end of the year, then the maintenance regulation would apply to any maintenance decision. So you would enforce via the maintenance regulation if it's a divorce that predates the end of the year, and recognition of French decision afterwards is the Hague Convention, as we've discussed. Over to you, Alex.
Over to me. Okay, so I will not discuss what would have happened before the 21st of December, because this is exactly what Lisette has said, and we apply the same rules. So what will happen right now if I have a case with two French in this situation living since 20 years in England, and the husband called me for the race to the court? We have to say the French court first, quickly, to avoid a bad English decision. Yeah. In this case, in fact, it is nearly different than it was before. It is nearly different because, indeed, there is not the dependence rules of the Article 19 of the Hague Convention that will apply, of the Brussels 2 bis regulation that will apply. And that will be an issue, because when you will decide to file in emergency in France for such kind of case, you have to think. You have to think, because, as Lisette said, in this case, the connection with England are so strong. Then, if the wife, on the other hand, file in England, then you will have two divorces, one in France, one in England, because the English court will keep jurisdiction based on foreign convenience, considering that there is closest link with England than the joint French nationality of these spouses. And in fact, you will have a big issue about enforcement. Indeed, based on the Hague Convention on maintenance obligation of 2007, the English decision will not be enforceable in France if the French court has been seized first. This is the Article 22nd of the maintenance convention, 22nd C of the maintenance convention. If there is a proceeding pending first in the other country, the decision will not be recognized. The issue is that if there is nothing to recognize in France, if all the assets are in England and the property are in England, in fact, you see that you will have a big issue in this kind of case. So this is for the French lawyer to be careful when in this kind of situation they will do the rush to the court and file in France first. They cannot say, like in the future, in the past, to their client, sure, we have secure jurisdiction. Perhaps we have secure jurisdiction, and if the wife came and filed in France, it would be perfect. But if she decides, if she go and see Lisette and she's a nasty lawyer and she decides to file in England, the husband is going to have a big issue at the end and a big problem. If there is a divorce proceeding filed first in England, and after the other spouse is filed in France, in this case, in fact, it will be the French court will normally apply the rules of dependence, because we apply the rules of dependence even with third countries. So this is not an issue on that point. This is more clear. This is clear for us normally. And if no, that's all.
Okay. That's okay. So that's illustrated that quite well. The second case study is just looking at a French husband and an English wife, but they're living in France for 20 years and the assets are in France. So how would that now look if they were divorcing from an English law and a French law perspective? So in this particular case, if that couple came to me and wanted to divorce, let's say the wife wanted to divorce in England before the end of the transitional period, Brussels 2 would apply, and I would say there's no jurisdiction, because as long as there's proceedings in France, then that is going to trump it, because you've just got sole domicile, and Brussels 2 revised says that that Articles 3 to 5 jurisdiction would take precedent. Obviously, if the husband wanted to divorce in England, then we could do that under Brussels 2 revised, and the Liz Pendleton rules would apply again first in time. Since the 31st December, it does change, because technically under English law, the wife could apply in England for a divorce. You've just got to look at, well, what's the consequences of her doing that? And obviously the husband could also apply in England for a divorce as well, if he so chose. But if the wife did it and there was a competing application in France, she's unlikely to get anywhere with her divorce, because it would be a forum non-conveniens case, and the English court would say this couple has very weak connections with the UK. So I don't think the English court would take it forward. But if there wasn't anything competing in France, then technically she could carry on with the divorce, and she could have maintenance and sharing claims, because we're not subject to the maintenance regulation that would prevent her from doing that, because she'd issue on sole domicile. So it would be a clear run. But as I say, I think that's unlikely if the husband wanted to divorce in France, or it's not possible. That really deals with, I think, where the finances were dealt with and the divorce. But what about recognition of any divorce? So if it was a French divorce, which it likely will be, again, we've dealt with how that would be recognised if it was pre the end of the year, Brussels 2 revised. If it was pronounced, or if it was commenced after the end of the year, then it's our domestic law. And again, I've said that the civil divorce is likely to be recognised in England, so that's not a problem. And what about enforcement of a financial order in England? Well, they're living in France, the assets are in France. Unless the wife's coming back to England, enforcement may not be an issue. But if she did and she had a maintenance order, then she could, if it was pre the end of the year, use the maintenance regulation. If it was post the end of the year, use the Hague Convention to enforce that order. Alex, over to you.
Up to me. Okay. So yes, in this case, in this kind of case, if we reverse this case and we put a French and an English in England, in fact, and in this case, the French will be able to file for divorce in France based on his own nationality, because we have this possibility. The issue is that the French court will have no jurisdiction to deal with the maintenance between them in case of divorce, because we will have to apply at that time the maintenance regulation, and we have an issue because the French court will have no jurisdiction unless if the wife accepts the French jurisdiction. There is this possibility, but out of that, there is no issue. So we can have just the divorce in France, but this is probably not the interest of this situation. So in a way, you have some guarantee that are strong in the new situation, because if you have new rules that are open based on sole domicile or sole nationality, these rules in fact are limited, and they are really limited to some question, and to the question of the divorce itself, but not necessarily the question of the maintenance, because, for example, in the case that, in the example of Lisette, if the wife came to England, get an order for divorce in England, and get a maintenance order in England, she will not be able to enforce it in France based on the maintenance convention, because there is ground to establish a jurisdiction of the court based to recognize an order on the Article 23rd of the maintenance regulation, and nowhere you will find the jurisdiction of the habitual resident of the domicile of one of the parties. So it will not work at all. So we have to be careful on the advice that we give to our client about that, because if there is some new possibility, this new possibility, in fact, are more restricted. So in a way, we need more than in the past this kind of organization to share experience and to share a point of view about how to apply the rules in both countries, and to have a colleague and network to be able to refer to.
Hear, hear. Go to a lawyer early on. Find out if you're going to enforce the order before you do anything else. That's it.